Have you been arrested for an injury to a child? Have you been arrested for spanking your child? Hi, I'm Jeff Hampton with the Hampton Law Firm. And I want to welcome you to our YouTube channel today. Today I want to talk to you about spanking, disciplining your child under Texas criminal law. Is that a crime? Should you be charged with injury to a child? By the way, if you wait around to the end of this video, I'll also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Okay, listen, if you've been arrested for the crime of injury to a child in Fort Worth or somewhere else in Tarrant County, maybe here locally in the area of North Texas, one of the things that will normally happen, maybe even before you're arrested, you may have been contacted by a detective. Because here's what happens. A lot of times, local detectives are trained to try to get in touch with you, and before they just decide to make an arrest, they want to accuse you. They don't just come right out and accuse you of abusing your child or doing something excessively. They want to come at you and try to empathize with you and see if they can speak to you and go over a few things for a few minutes. First of all, I want you to understand, if you are the subject of an investigation for an injury to a child case, it's a very serious matter. You need an experienced and aggressive criminal defense attorney in the North Texas area to make sure and protect you, particularly if a detective is trying to get in touch with you. You see, I want you to understand, I get the reason why an injury to a child statute exists in Texas. It's designed to protect, and I say injury to a child, it also includes injury to an elderly person. It's designed to protect the most vulnerable of our citizens. The problem is, it can be overbearing if you've done nothing wrong. Sometimes detectives want to try to force something without being able to actually prove it. So the first question I get all the time, I get tons of people that call me and say, hey, listen, I've gotten a call from this detective wanting me to talk about the fact that I disciplined my child, and they're wanting me to come in and talk to them and have an interview with them about this. And look, it is common that an investigation for an injury to a child will easily last weeks up until months while the police department's looking into it. During this period of time, the detective is likely, almost always, they are trained to want to get in touch with you. They're going to want to speak to you. They're going to want you to come in and sit down with them and go over some things. And listen, they're going to tell you that they want to hear your side of the story. But I want you to understand, it's not going to work that way. If you go in and meet with that detective, he's not going to just let you sit down and start saying whatever you want to say. What will end up happening is they're calling you for one reason. They want you to confess to something. It's going to turn into more of an interrogation. And literally, here's what will happen. You go in, if you start to speak to the detective will say, look, we already know this. Here we see that your child was disciplined this way. We see, let's say hypothetically there's a bruise on their bottom or whatever's going on. They're going to say, listen, we already know what happened on this. So go ahead and just tell me you did this, right? I mean, it's going to go better for you if you just go ahead and let me know what happened now. Please understand, everything that you say can and will be used against you if you go in and talk to that detective. For example, maybe you've been dealing with your 10-year-old child and they were being disrespectful and violent towards you in some way. As a parent, you made the decision to discipline your child by spanking them on the backside. Your child maybe then goes to school the next day and the teacher learns about that spanking from your child, and the police are called and an investigation is launched into an allegation of an injury to a child. You know that you've done nothing wrong, so when a detective gives you a call and asks you to meet up with him to give your side of the story, you happily agree, okay? Now, when you arrive, the detective immediately begins to grill you about what, in fact, he already claims that he knows about your case, and he only needs you to admit to hitting your child because he believes he already knows what took place. You become terribly upset. You feel like you've been convicted in the mind of the detective already. You try to explain that you were only trying to reasonably discipline your child because of their behavior. And what you don't realize is that while all this is going on and you're trying to explain yourself, the detective is writing down that you confessed to striking your child. This confession, quote unquote, can then be used to obtain an arrest warrant for you to be taken to jail. Now listen, if you choose to hire an experienced criminal defense attorney, your decision to exercise your Sixth Amendment right to counsel will protect you from being interrogated or misinterpreted, you name it, manipulated even by a detective in terms of what they believe. Here's the key. Everything your criminal attorney says is hearsay and cannot be used against you. So by collaborating with your attorney, your criminal attorney, you are able to ensure that the correct information is provided to the detective without jeopardizing you trying to say something and it being misinterpreted or misapplied, okay? Now let's talk about the elements of the crime of injury to a child or the elderly. So according to Texas Penal Code Title 5, Assault of Offenses, Section 22.04, the Tarrant County District Attorney's Office will be required to prove the following elements of injury of a child beyond a reasonable doubt. Here it is. A person commits the offense of injury to a child, elderly individual, or disabled individual if he intentionally or knowingly or recklessly by act or intentionally, knowingly or recklessly by omission causes to a child, elderly individual, or disabled individual serious bodily injury, serious mental deficiency, impairment, or injury, or number 3, bodily injury. Now, the definition of this crime can seem very confusing. And I know I just read it to you pretty quickly, okay? But here's the thing. One critical issue to be aware of is that the definition of injury to a child or elderly does not include accidents. In other words, if what took place was purely an accident, the state of Texas is going to have a very difficult time proving the crime of injury to a child. For example, what if you were in the kitchen making dinner and your 5-year-old jumps from the couch to the ottoman and misses the mark, resulting in him breaking his leg? If the police were to get involved and claim that you were negligent or claim that somehow it was your fault because your child chose to get up on that ottoman and jump from an ottoman to a couch, then at that point, what would they be able to claim? What? That somehow you were reckless or that was something that was intentional or knowingly on your part? Absolutely not. That was an accident. The prosecutor would be required to prove that you, as a parent, had the criminal intent to act by neglecting the child that caused, as a result of your actions, caused that injury to the child. Look, accidents are not covered. I use that example because I have a very rambunctious 5-year-old child. My son did exactly that. He jumped from the ottoman over onto the couch. He missed the couch. So my point is, if everyone could be charged with injury to a child because their child got hurt while they were at home, everyone would be in prison, okay? So understand, accidents do not count. Now, when does an injury become criminal under Texas injury to a child law, okay? Well, the accused must have contacted the child or the elderly person in a manner that caused serious bodily injury, that's number 1, or bodily injury. Now let's define serious bodily injury. Serious bodily injury under Texas criminal law is defined as sustaining a permanent or protracted loss of use of a bodily member or organ. Examples would be an injury that results in blindness, being permanently crippled, or disfigured in some way. Now, let's talk about bodily injury. So number 1 is serious bodily injury. Number 2 is bodily injury. Under Texas criminal law, it's defined as contact that results in physical pain. Does that mean there must be proof of bruising or scratching to prove bodily injury? Not necessarily, but failure by that prosecutor to be able to provide evidence of an actual injury makes an injury to a child case extremely weak and would certainly assist in helping get your injury to a child case dismissed. Now, for the Tarrant County District Attorney's Office to be able to substantiate an injury to a child or an elderly or disabled individual case, there are certain things that must be proven. And one of those is we need to understand the definition of a child. Number 1, a child means a person 14 years of age or younger. Number 2, an elderly individual means a person 65 years of age or older. And then number 3 is a disabled individual, means a person older than 14 years of age who by reason of age or physical or mental disease, defect, or injury is substantially unable to protect himself from harm or to provide food, shelter, or medical care for himself. Now, here's where it kind of gets a little bit more complicated when you start talking about punishment ranges, the severity of the crime. That depends on the eligibility or the situation with the alleged victim. The Texas Penal Code states that injury to a child, an elderly individual, or disabled individual is a felony of the first degree if the conduct was committed intentionally or knowingly. A felony of the first degree is punishable, talking about a first degree felony, punishable by a minimum of 5 years up to life in prison and up to a $10,000 fine. Now, if that conduct is engaged in recklessly and it caused serious bodily injury, you're now talking about a felony of the second degree. A felony of the second degree, a second degree felony is punishable by a minimum of 2 years up to 20 years in prison and up to a $10,000 fine. Now, what if it wasn't serious bodily injury, but instead bodily injury, that lower level? That bodily injury, an injury to a child, if the action was committed intentionally or knowingly, the crime is now a third degree felony, punishable by a term in prison of not less than 2 years, up to 10 years in prison, and up to 10 years and up to a $10,000 fine. Now, here's the real question. Is spanking your child illegal in Texas? That's a big part of what we were talking about in this video. One of the most common fact scenarios where a Tarrant County citizen is charged with injury to a child is when the police allege that you excessively disciplined your child. Now, the Texas Penal Code states that an injury to a child is a state jail felony if that person acts somehow in criminal negligence. Now, a state jail felony is punishable by a term in prison of not less than 180 days and up to a 2-year prison sentence and up to a $10,000 fine. But here's the rule on this. It is important to understand that if you have reasonably disciplined your child, you are not guilty of injury to a child. Look, corporal punishment is legal in Texas as long as it is reasonable. You know, the problem though, right? Reasonable is in the eye of the beholder. What someone thinks is reasonable, other people don't. In fact, there are many people who think that spanking a child is never reasonable. So it really depends on how your view of it is. Now, under Texas law, you still can use corporal punishment on your children, but regardless of anyone's opinion on spanking or corporal punishment, you do have that right. But be careful. It doesn't mean CPS might agree with that. It doesn't mean that an overzealous detective might not try to make something out of this. So as long as that discipline was reasonable, spanking is legal. Now, what can you do if you're innocent of an injury to a child case? First, you need to hire an experienced criminal defense attorney to manage all the communication with this detective and guide you through the process in the event that detective decides to try to get a warrant issued for your arrest. Your criminal lawyer can then access all the evidence in the case, all the digital media evidence, go over it with you in detail, begin to plan your criminal defense. And after reviewing your case, there may be some evidence in your case that immediately establishes the fact it does not appear that you've done anything wrong. And I'll just tell you right now, your criminal defense attorney needs to prepare a presentation to a grand jury. The grand jury is a panel of citizens that every felony in the state of Texas has to be heard by a grand jury. That grand jury is a filter. It filters out bad cases, it's supposed to, and it keeps the legitimate cases and moves them on down through the court system. But the problem is, if your criminal defense attorney does not provide that evidence through a grand jury packet, an evidence packet, the grand jury may never hear your side of what happened to get rid of your case. So the grand jury really has 3 choices. They can true bill the case. A true bill means they approve the case and keep it as a felony. They can, number 2, reduce the charge to a lesser charge, maybe down to a lesser misdemeanor offense if it's appropriate. Or number 3, they can no bill the case. A no bill is the equivalent of a dismissal of all charges. It's the best case scenario, and in that situation, you would be eligible for a complete expunction of your criminal record. Now, listen, if you are facing a charge of injury to a child, elderly, or a disabled individual, it is imperative that you contact a criminal defense attorney immediately. Listen, at the Hampton law firm, we are a team of defense attorneys, all former prosecutors, defense attorneys here that we specialize in doing criminal defense work. We have over 80 years of criminal law experience and over 500 criminal jury trials in the courts of North Texas. And we would be happy to provide you a free consultation. Don't hesitate to contact us at 817-877-5200. Be happy to give you that free case analysis. And by the way, I promised you if you waited around to the end of this video, I'd give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Click the link below, down in the notes of this section, and I'll be happy to send that right over to you. Thanks for joining us today. We'll see you on our next video.